If this video about a purple house piques your curiosity, be sure to visit constitutionalcounty.org. It's August 12th, 2026. Welcome to yes2hellwith.com. You own your own home. No HOA, no historic district, no private covenant controlling its color. One Saturday you decide, I'm painting my house purple. You buy the paint and begin. Then a zoning official arrives. You can't paint your house purple. You ask, why not? He cites a municipal regulation and orders you to stop, to restore the approved color, or to face fines. Now forget about purple for a moment. The real issue is simple. You own the property. Government has crossed that boundary and told you what you may or may not do with it. Maybe the government has lawful authority to do that. Maybe it does not. The question is, where is the boundary and who determines whether the government has crossed it? Let's run the scenario two different ways. Scenario one, you challenge the order, hire an attorney, pay him thousands of dollars. There are motions, hearings, briefs, and you lose. You appeal, more lawyers, more money. Meanwhile, the fines accumulate, $250 a day. Perhaps the city threatens a lien. 2 years pass, then 3 and 4. You spent thousands and tens of thousands of dollars over what color you may paint your own house. Finally, the highest court that you can realistically reach says, no, the ordinance stands. Now, a property right does not mean every regulation of property is unconstitutional, but assume for our hypothetical that this particular restriction really did exceed constitutional limits. That changes the question. You possess the right. Government crossed the boundary. You used the remedy that government provided. And 4 years later, the system still didn't protect that right. So what did you actually have? A right without an effective remedy. Now let's look at scenario number 2. Same homeowner, same house, same purple paint, and the same zoning official. But this time, when the city threatens enforcement, you call the sheriff. The sheriff becomes involved, and the sheriff simply doesn't take the homeowner's side. He investigates. He reads the ordinance, examines the authority under which the zoning official is acting. He considers the state constitution and the federal constitution. He asks, what government interest justifies this interference? Does the ordinance actually authorize it? Does that authority extend this far? And suppose the sheriff concludes that enforcement would exceed the city's lawful authority and violate a constitutionally protected property interest. Now something changes. The sheriff tells the city, I will not participate in enforcing this action, and I believe the constitutional boundary needs to be resolved before government proceeds against this citizen. That doesn't make the sheriff a judge, and it doesn't make him an unlimited authority. The sheriff is bound by the Constitution and the law, just like the zoning official. He cannot arrest or cite anyone simply because he disagrees with that person's interpretation of the Constitution. But suppose state law provides an applicable offense for the official conduct involved and the facts establish the required legal basis. The sheriff investigates. The lawful process is invoked, and suddenly the constitutional question is no longer 4 years downstream. It's at the point of enforcement by the sheriff. The dispute, because he files a charge against the zoning administrator, reaches court. The city must defend the authority being exercised. And in our hypothetical, the court concludes the city exceeded its lawful authority. So the city backs down and the homeowner finishes painting his house purple. So what changed? not the Constitution, the homeowner, or the ordinance. The remedy changed. In the first scenario, the government acts and the citizen suffers the consequences. Then the citizen spends years trying to undo it. But in the second scenario, government attempts to act. Another lawful authority examines the boundary that was crossed, and enforcement is challenged before the deprivation becomes irreversible. That is the counterweight, and the sheriff's role isn't that he outranks the zoning official. It is, before I participate with force against this citizen, I will establish the lawful authority for what government is asking me to enforce, or in the event of the citizen filing a complaint, he investigates on behalf of the citizen and levels charges against the city and its officials. If the authority exists, government proceeds. If it doesn't exist, government should stop. That's the principle. The purple house seems trivial. That's what makes the example useful. Because today the question might be, can I paint my house purple? Tomorrow it might be, can government take my business, my property, my home, my liberty? And then the question becomes much more serious. If the Constitution establishes a boundary around government, where is the practical remedy when government crosses it? A right written on paper is important, but a right with an effective remedy is what makes the boundary real. There are constitutional limitations for a reason, and we have rights that are inherent from our Creator. And as always, may truth reign supreme.